All right, guys, we might as well start. Nobody's entered for the last minute or so, so let's begin. Okay, so welcome to our fifth class. So one more class this week, and which is going to be your midterm exam, which I'll talk about in a few moments. And we're halfway through the course, so we're flying right along. So before I ask for anybody's comments or questions with respect to the YouTube videos I posted online this week. A couple of things. So everybody will have now seen, I would hope, the topic on Moodle for groups, presentations, and memberships. So I've divided everybody into 5 groups. I used the groups that we used for the breakout questions last class. You were all given the option, if you wanted to rearrange yourselves somewhat in those groups, but you needed to do that amongst yourselves. Me doing it from the outside would have made things pretty cumbersome. You can still do that, although I was kind of hoping that that would take place by tonight, but you certainly need to get it done this week. There's no question about that. We had one student who I missed in the allocation of the groups, and that's Genwan. So I'm going to put Genwan into group number 5. All right, so those of you in 5, you have an additional member, so I'll add that name to the group list on Moodle. Everybody should also have now seen the question for the group presentations, which is essentially revolves around, and it was very big news in February, March, and April this year, the protest that arose as a function of the position taken by the Wet'suwet'en hereditary chiefs in Alberta with respect to the expansion of the Coastal Link pipeline, the gas pipeline going from Alberta to British Columbia. So it was a really big news item in this past spring. So you're not going to have any trouble whatsoever getting the fact situation put together as to what happened. So all of you, all 5 groups, have a very different perspective that I want you to present to the class and to me, obviously, on the last class, which is the second week of July. All right, so the one group is going to take the position of the hereditary Wet'suwet'en chiefs. The second group will take the position of the Wet'suwet'en First Nation chiefs and council. All right, so you have to keep in mind, of course, that those are two totally different governmental structures for Indigenous peoples of the Wet'suwet'en Nation. Another group is going to take the position of the federal government of Canada. And then the 2 remaining groups, one will take the position of the province of Alberta, and the last one will be the province of British Columbia. All right, so all of you will have the same fact situations to deal with, but will have a very different perspective, particularly with respect to the environmental issues, with respect to the expansion of the coastal gas pipeline. And that's what it really was at its heart, an issue of the environment and who really had control over that particular resource development. All right, so those are the groups. Anybody have any questions about the group presentations at this point? Everybody good? You're in a group. Again, if you want to just rearrange yourselves over the course of the next few days, you can certainly do that. But again, you have to email each other and add and subtract from the groups as best you can. All right. The second thing to talk about before we get into the questions and comments is the midterm exam. So that's taking place on our next class. So what'll happen is at or around 7:05 p.m., I will email you all, using your class alias, a Google form that will be your midterm exam. It will have 60 questions on it, a combination of true and false, multiple choice. It will deal with the first 5 chapters in your textbook, which is up to and including what we're going to be talking about tonight. I'll give you a couple hours for the test. Some of you may take that long, but I doubt it. But it's certainly up to you to do it within a couple of hours. What else can I tell you? It's open book, right? So that's a really good thing. So each question will have a reference to the page number in your textbook where the answer can be found. So you don't want to necessarily be searching for those answers with each question. You want to pretty much already have a pretty good idea what the answer is before you actually do the exam. and then you can confirm that answers by flipping to the various pages. That's up to you, but again, you have 2 hours to do 60 questions, so gauge yourself accordingly. Any questions about that particular item, the midterm exam? Okay, it's worth 20% of your final mark. All right, guys, let's talk about, I posted on Moodle 2 YouTube videos for you to take a look at before tonight's class. One was on it was a policy piece by a couple of, well, one professional who is very active in the environmental movement in Canada, and she was talking fundamentally about the success and or failure of the current federal government with respect to environmental principles and policies in Canada. The second YouTube video was from a program called The Agenda. Steve Paikin is the host. He's been doing this for a long time. And it was an interview of various players who had comments with respect to what is known as the Walkerton water tragedy, which took place in and around 2000, 2001 in a small town in southwestern Ontario called Walkerton. And you could probably tell from the background they gave in that video and the further discussion that was had, that what essentially happened back almost 20 years ago now is that the water treatment plant for the town of Walkerton was run by two brothers. And these two brothers, one of them and or both of them had serious drinking problems. And what they did is they did not properly ensure that the drinking water for the residents of Walkerton, and it was a town of about 5,000 people, they didn't ensure that the drinking water was in fact potable or drinkable. And in fact, they didn't do anything, they didn't chlorinate it or whatever they had to do. And what happened is E. coli got into the drinking water, which is essentially fecal matter. And in a very relatively short period of time, virtually half the entire population of Walkerton became ill with stomach cramps as a function of the E. coli, and 7 people actually died. So it was an incredible tragedy, especially for a small town. And so, as you also would have seen from the video, a public inquiry was put into place. Justice Dennis O'Connor of the Ontario Superior Court of Justice was put in place as the commissioner of that inquiry. There were criminal charges brought against both of those brothers. I think their last name was Cable, both those brothers, and they were in fact convicted of criminal negligence causing death, and in fact went to jail for that. So having said all that, so those are the 2 videos I gave you, which are a really good big prelude to tonight's lecture. Anybody have any questions or comments about those videos? And of course, this goes obviously to your participation mark. So anybody want to chip in and have anything to say? No comments or questions?
I guess, sorry, just, oh, sorry.
Go ahead, Joy.
Right, sorry. I was just going to ask more just so for the first video, the one in regards to like our current, Justin Trudeau and the Liberal government right now, they sort of had a lot of, sort of bad and sort of good things to say about him. I'm just sort of curious what your take on his sort of like take on the environmentals, like how he's made some promises, he's made some advancements, but also really hasn't with adopting Harper's emission reductions targets and all those things, et cetera. So.
Yeah, I think she said it really well, that the speaker in the video, thanks Joy. Yeah, so Trudeau has done certainly more than Harper ever did. Harper was not an environmentalist of any kind. Trudeau professes to be, and what he has done, which is fairly monumental, is put into place the system of carbon taxation in the country. So he put it in place. Provinces, if they put it in place themselves, they could have that. And if provinces don't put it in place, then the federal government imposes it in those jurisdictions where the provinces haven't stepped up. It is a significant step towards carbon emissions by putting a carbon tax on things. And the whole point of that, of course, is for individuals and industry to basically pay attention to their carbon footprint. So that was a very progressive kind of thing, and Trudeau's done that, and he's stuck by it. And all the science behind it supports what he's done, even though various provinces have objected to it. But most of them are backing off that position now. They really don't have a working alternative. The fact that the government has backed off on limitations, climate change, as in no greater than 2-degree increase in the planet over the course of the next 30 years. The fact that the government has backed off on that and in some respects mirrored what Trump had to say is troublesome. And so I think what her position was overall is that Trudeau has done certainly better than what Harper had done in the 10 years he was in power, but he's got a lot more he can do. Okay, Kate raises her hand. Kate?
Hi. I just thought it was interesting. I think it was in the
Can you speak up, Kate? I'm sorry, I can't hear you.
in the second video. Can you
Okay.
hear me now, or? I just thought it interesting that they said that Indigenous people suffer the most with contaminated water and inadequate drinking water.
Yeah, it's still really hard to hear you, Kate, but I think in case anybody else had trouble hearing, Kate was talking about the reference in the agenda piece on how water quality has certainly adversely affected Indigenous peoples, and it really has. I mean, almost all of the boiling water advisories in Canada are on First Nation reserves. So it's a big deal, right? I mean, we have First Nations across the country. There's 632 or so First Nations. The fact that a great many of them do not have and have not had for decades drinkable water is a real problem, right? And it's something that could be fixed. It's not a hard fix. It's a fix that, of course, it just takes money because it involves engineering and putting into place water treatment facilities. And that's the federal government's obligation to do so. So the reference to water treatment and water control adversely affecting Indigenous peoples is absolutely true. It does. People shouldn't have to live on a daily basis, year in, year out, with not having potable water to drink with. So yeah, absolutely, it's a problem. Okay, Shivani, you had a question?
Yeah, no, I want to comment on something.
Sure.
So for the first video, yes, I do agree that the government can do much more to preserve the environment. Like, even though he's implementing like methane regulations and carbon taxes, but I don't think it is in balance with the amount of emissions that is going into the atmosphere on a daily basis. So I believe that he can do much more to preserve the environment. And additionally, I would say that Justin Trudeau is like too passive in a sense, because I remember in the video it says that there was an agreement between the United States and Canada. It was implemented by Barack Obama, but Trump decided to delay it. I think it's to minimize the amount of fossil fuel in the atmosphere, releasing in the atmosphere.
Yep.
So, right, basically, Trudeau agreed, right? But as Trump decided to like delay the process, he decided to delay it for Canada as well. So I'm saying that he's basically watching the United States to make an impact in Canada, which it shouldn't be like that, So I think he needs like better like leadership qualities, because this isn't in relation with what I'm saying, but I remember with the COVID crisis and Canada closed the border, right? But they kept it open for the United States. And like people are asking, why are you keeping it open to the United States? And most of the cases that are imported in Canada is from the United States. And he didn't have any strong answer to back up what he did. So I'm saying that he can do much more and not just sit and rely on the United States to make decisions before he makes decisions.
Yeah, good points. And the other thing that they didn't highlight in that particular video, but it's really important, is that one of the things that Obama did while he was in power is he put in place a process to, in fact, eliminate any expansion and the reduction of coal-fired power plants, right? And 25 or 30% of all the energy in the U.S. is still fired by coal, which is obviously an incredibly dirty source of fuel. And Trump, very quickly reversed all of that as well. And Trudeau, and we have coal in Canada. We have most of it is in the Maritimes. Trudeau didn't and has never really slapped down Trump for almost anything it did, and we understand politically why that is. But it's really an important issue because coal is a terrible source of fuel, and having power plants that still use it to generate power is antithetical to clean energy. Shell, you had your hand up? Michelle?
Yeah.
You
Can you
have your
hear me
hand up?
now?
Sure.
Yeah, I did. Is there two different Indian groups? Because isn't the government partnered with some First Nation groups for is it the tar sands or the pipeline or some energy oil company recently?
You know, if you're talking about Alberta and British Columbia, there are, for instance, with the Coastal Gas Link, which you guys will talk about in your group presentations, there were a lot of First Nations on the route from Alberta to British Columbia that had signed on to it. It went through their traditional territory, and they signed on to it because, and we talked about this a couple of classes ago, they, as a function of the resource extractions going through their territory, they had to do they had to consult and accommodate them and enter into impact benefit agreements with them so that they would share in any profits being generated by the construction of the pipeline. So, you know, for instance, if the pipeline is being put in place by this private company, Coastal GasLink, it's going through the territory, then they would be obliged, for instance, to hire First Nations for the construction of that kind of work. So, and that has to be agreed to by the federal government, of course, because again, they have jurisdiction over Indigenous peoples, the Indians and lands reserved to Indians constitutionally. So yeah, there's lots of, you know, there's 630 odd First Nations. There's other nations that aren't First Nations, as in they're not created by treaty, like the Wet'suwet'en hereditary chiefs is not a First Nation. So, you know, there's lots of moving parts. There's lots of projects where you know, for environmental purposes, the Indigenous groups very much oppose what's going to take place, and some for economic reasons, in fact, approve of them and support them. So yeah, it's not, you know, Indigenous peoples in Canada, just like anybody else in the world, they're not homogenous, right? They're not the same. They have different interests, they have different cultures, somewhat, and different things that they want to see happen. So if one group supports the environment, another group may support the economy. It's totally up to them, essentially. Okay, we also have Adam. Did you have your hand up? Adam, yes, no. So Williams posted this on the chat. He says he thinks the problem with slamming Trump is his ability to stop export imports for Canada. Do I think it's right? No, but Canada's economy relies on that of the US. We can self-sustain, but the quality of life for Canadians would diminish. I think Trudeau is making the hard choice of biting his tongue at times. He should be more vocal, but I feel he's putting the economy before his ideals. I think that's absolutely true, William. That's very much on point as to why, to a great degree, Trudeau does not directly criticize Trump, because Trump is very sensitive about anybody criticizing him. He takes it as a personal affront. So William's quite right. You know, from a political point of view, things that affect us fundamentally in our economy, because the U.S. is still our largest trading partner, he remains quiet instead of criticizing Trump on various issues, including things like the environment. Arette, you had your hand up?
Yes, I do. You have touched on my question from William thing, but I just wanted to point out our question, the reason as to why water is not on most First Nation. And I would argue that this is not just a federal issue. I think some of these issues may be contributed to some First Nations themselves, and also the geographic location of where these nations are, which affect some of those difficulties that they face with the water issue. Secondly, regarding the pushback on Trudeau's and his efforts regarding environmental issues, I think Trudeau's government is doing good, or he has done pretty good with different constraints he has. I think a few things that limit his ability to even do more is the politics of the day, not just foreign, but local politics, as it relates to his opposition, who is always giving him pushback, which sometimes is unreasonable. just to score political points. So that's one major obstacle he faces. And even more so today, him having a minority government, right? That's also limit his ability to push things through. And then Canada has to somewhat maintain competitiveness on the international market. So when we look at what the US is doing, as they're not fulfilling the agreement on the carbon emission and all that, Canada has to still maintain some degree of competitiveness where their industries are still surviving. Because if Canada adopt all these rules and all these restraints, when other nations, US and China, India, is not doing as much, as it will place Canada at a disadvantage. Focusing on economic growth, we need that, but it has to coincide somewhat with what's going on and how we protect the environment. Canada alone cannot protect the environment. So I would argue that Justin is doing a good job with in the space in which he has to operate. And as William noted, the economic dependency on the US and other partners has much to do as to how he pushes this agenda. That's my thought on that.
Yeah, thanks, Red. And in line with that, I mean, Pete has also posted that Trudeau has to be in sync with the U.S. economy, so his hands are tied as far as the environment. But that goes back to a point that Red made a few minutes ago with respect to the fact that Trudeau is in a minority position. So you have to remember, as a minority government, he can't get anything done unless he gets the cooperation of other parties. He's not going to get the cooperation of the Conservative Party of Canada. That's the official opposition. They don't want Trudeau to get anything done because they want the government to fall. So he has to fundamentally rely upon the New Democratic Party, which is the next party in power. And the New Democrats are very, very environmentally based ideologically. So interesting point. I mean, Trudeau, if he wants to get legislation passed, he's got to basically have the NDP on their side. But in that regard, he's not going to get anything passed if it deals with the environment unless the NDP agrees with it. So that's an interesting political point. Somebody else? Any comments on that? Lexine? Just making noise, not doing a question?
Yes.
Okay.
Definitely. As it relates to the video that says just how environmental are Canada's environmental policies, I have a question, right? If the position of the 6 degrees are taken, how will it benefit Canada?
Well, it won't. I mean, the position of the 6 degrees is a disaster for the world. The target is less than 2 degrees Celsius. So anybody who supports the 6 degrees is way beyond what everybody accepts as being legitimate.
Okay.
I have a question.
Okay, sure.
Would you say that the tap water is safe to drink here in Ontario, especially Sault Ste. Marie?
Okay, well, I would hope so. I mean, we do have water standards in place. We have a water treatment legislation in place. We'll talk a bit about that tonight. So I would hope that it is. I think watching the Walkerton video, where, for instance, the former Minister of the Environment in the Mike Harris government, which was Conservative, said that Walkerton's water is probably as pure as anything on the planet because of what happened there. I would hope that the testing that's done, the treatment that's done, is certainly well monitored. And nobody is going to want to see another Walkerton take place. So I would think it is. I mean, but again, it's only as good as those who do the treatments and those who do the testing. So I'm just saying that out loud. I don't have any empirical evidence to say how good or bad Ontario's water is.
Well, because when I just came here, people were saying that the water, like the pipeline in Michigan, it's not safe to drink. So because we're so close, so I was really concerned,
Well, again, it depends. I mean, the water in the Soo either is going to come from the St. Mary's River or it's going to come from wells. For instance, Toronto, its water comes from wells, and that's a very big population of service. But again, it's a function of where the water comes from and how well it's treated. if it, if the water from St. Mary's is not necessarily a great quality, then we hope to have obviously a good treatment facility in place. And there's no comparing, what our treatment facility is on this side of the river versus what they have in Sioux, Michigan. I have no idea the quality of their treatment plant there, but that'll make the difference between. We don't drink the same water. The water that comes into our glass isn't the same, even though we're both on the same side or on opposite sides of St. Mary's. One will have better or worse water quality based upon how well it's treated. So honestly, I can't say how well it's treated here, and I don't know how well it's treated in Sioux, Michigan. So I'm afraid that doesn't answer your question, but it gives you the context for how water, should or should not be looked at. Anybody else? There's a bunch of hands I saw a few minutes ago. Kate, you had something to say? Kate asked the question, wasn't there an incident here in the Sioux not many years ago concerning water? I've only been here 7 years, so I don't know. Does anybody else know? No? Tyler, you have something to say?
Yes. Sorry, can you hear me?
Yep.
Okay. I just wanted to reflect on the Walkerton tragedy. Made me reflect and think a lot about the recent crisis in the United States in the water in Flint, Michigan, which has recently resulted in revision of some regulations with respect to the drinking water there. However, this was a tragedy that spanned for years, and I know Obama was asked to declare it a crisis but chose not to. And it's just in the past year or two has resulted in revisions of certain federal regulations. However, that was in the United States.
Yeah, the Flint, Michigan water tragedy was far more tragic than Walkerton, only because of the size, compared to the size of the population affected. Anybody else? Any other questions or comments? There's a few hands up before. Let's just see, is there anything on chat? And one of, no, let's see here. And one last thing from Pete, he said the Walkerton brothers were at fault, but should not have been left as the frontline prevention for what happened. Pete, what do you think about that? Why do you say that?
I listened to the film about it, and it said there was a double check, but the second check only reported to the Walkerton brothers and should have been sending reports to the Ministry of Environment, I guess, as a double check rather than just relying on the two Walkerton brothers.
Right. Good point. I mean, again, it's a function of the failure of the bureaucracy, right? And so, when it comes to things like something so elementary as good drinking water, you would want to have more checks and balances than just relying upon two brothers who were clearly incompetent. Rhett, you had your hand up?
Yeah. Can you talk a little bit more on perhaps the issue of water not being available to all First Nation, or them not having quality water? This issue seems to have been one that's been dragging on for many, many years. It's not new to us, but yet there's no fix. We keep on going back to the effort of the federal government, but does responsibility lie solely with them, or what do you think are some of the limitations? Because again, like I said, this issue has been dragging, and it has been discussed in several forums.
The responsibility lies fundamentally with the federal government, but it also lies with the First Nations, because over the course of the last 20, 30 years, the federal government, while they are fundamentally responsible for Indians and lands reserved for Indians, which is where the boiling water advisories are, they do give band councils money to address this, but they don't police it. So they have given band councils tens of thousands of dollars to try to clean the water, as best they can. And sometimes the money is well spent and sometimes it's not. But fundamentally, what really has to happen, and Trudeau promised this in the 2018 federal election, is that he would in fact invest funds in the infrastructure to bring the water treatment plants up to scratch. And that's, and again, it's just engineering. So almost all First Nations, live near or on a water supply, a river of some kind or some body of water. So the engineering is not, it's not rocket science. It really isn't to basically put in a small water treatment facility. And remember that First Nations don't tend to be highly populated. People on First Nations are in the hundreds, not the thousands for the most part. So a small water treatment facility, should be workable in most First Nation communities. So, if the federal government it does not provide enough funding for a facility, then it needs to provide enough funding to the band to do something in the alternative, which usually ends up being something like, bringing in bottled water, which again, is a highly cumbersome and not a very satisfactory way for people to live, in that, they have to, have bottled water for the drinking water, and then, for their food, they boil the water. And then, when they take baths and what have you, it's not in, it's not in high quality water when you take baths. And if you're children, you're going to get the water in your mouths and all those kind of things. So it's a mess. So it really needs to be addressed in a really comprehensive way, which, notwithstanding political promises, really hasn't been done as well as it should have been. And it really is a very fundamental thing, having clean water to drink. Tyler?
Sorry, that was a mistake.
Well, okay, no problem. Anybody else? Arette, does that answer the question?
Yeah, it does.
All right. Okay, Pete had another thing on chat, so you can see it there. It's to everybody. Anything else, guys? Any questions or comments regarding these two videos? One, Canada's environmental policies, and two, the Walkerton tragedy? Yes, no? Alrighty, so let's move to the lecture.
Sorry, before you go,
Sure.
one thing, not concerning this, but for the midterm though,
Okay.
Will you give us any areas to focus on, or the midterm will be spread across all the lectures that we have completed? I'm not sure if you had mentioned that before.
Yeah, no, no, there's no area to focus on. I mean, but again, it's because it's open book. Clearly I'm going to focus the questions on what's actually in your textbook, right? Which I expand upon in my lectures. But again, you're going to be able to find the answers in the text. So, if you're all very cognizant of what's actually put in those first 5 chapters, and then you'll do very well.
Okay. All right.
Okay.
Thank you.
All right, guys. So let's do the lecture. All right. So there's 3 PowerPoint slides tonight. The first one is on regulatory regimes and environmental protection. The second one is going to be on administrative penalties, administrative monetary penalties, and the last one are going to be on environmental offenses and how, in fact, prosecutions take place in that regard. Okay, so this is the Regina and the Wholesale Travel Group is a really, really famous environmental case, and I'm just going to read to you from what it says, just to start this off. So regulatory measures are the primary mechanisms employed by governments in Canada to implement public policy objectives. It is difficult to think of an aspect of our lives that is not regulated for benefit and for the protection of society as a whole. From cradle to grave, we are protected by regulations. They apply to the doctors attending our entry into this world and to morticians present at our departure. The more complex activity, the greater the need for and the greater our reliance upon regulation and its enforcement. All right, so that's a very broad sweeping statement, but incredibly important, basically. There's been an extensive body of regulations that has been formulated to protect the environment. And before we go any further, let's make sure you understand, and this was referenced in our second class when we talked about Canadian laws, the difference between a statute and a regulation. So does anybody want to offer their opinion on the difference between the two? Tyler? Yeah, Tyler?
Yes. A regulation can be changed a lot easier than a statute can be changed.
And why is that?
A statute is takes more of a process in court, and it's more binding to legislation.
Yeah. Oh, that's great. Yeah. Anybody else?
Yeah, so based on my understanding, like a statute are like laws that are made by Parliament or the legislature, known as acts, basically. And then regulations are like rules that address details or practical applications of law, not basically law, but that.
Excellent. Yeah, regulations are law. They're considered to be what are called secondary statutes, but Lexine and Tyler are both correct. So statutes like the Water Protection Act or the Environmental Protection Act, things that we talk about, they are passed by a legislative body. So if it's a federal statute, it's passed by the Parliament of Canada. If it's a provincial statute, it's passed by the legislature in Queen's Park in Toronto, the provincial government. And they pass statutes, which are also called acts. It means exactly the same thing. But each one of those statutes will almost always have a provision at the end of it saying that the governor in council, which means the cabinet, has the right to enact regulations to apply to the law that's been basically set out in the statute. And they really, and this is what Tyler said, the really great thing about regulations is that because they're handled is in the government, but not as formally as a statute, then departments, the Department of the Environment, the Department of of Foreign Affairs, all these various departments we have that are cabinet departments can change regulations at will, right? They don't need to pass they don't have to introduce a bill into Parliament and have it go through all the steps to get it approved, and then to either have it agreed to by the Governor General or in the provinces, the Lieutenant Governors. Right, so it's really important. So statutes are very flexible, and as Lexine has said, they bring into effect the law that the statutes have, but they are in fact laws themselves. All right. So by way of introduction, right, we have basically most environmental law in Canada is public law. Right, it's public law as in a level of government brings it into place. So for our purposes, either the federal government or the provincial government. That's public law. Private law, and we're going to have a class about this in a couple of weeks, dealing with the environment, is a separate kind of law. It deals with disputes between individual parties. Now, a party could be the government, but it also deals with John Smith for, suing Jane Doe, those kind of things, or you suing No Frills for some reason. It's a dispute between parties. And so, and they're done by way of what are called causes of action, which could be torts, like negligence or nuisance or what have you. And, they rely upon the common law, right? So we talked a bit about that in the second class, the common law being the law of England that we brought to Canada, which is judge-made law, case law. That's the common law. In Quebec, in this sphere, it's the civil law of Quebec, the Napoleonic Code, the Civil Code of Quebec. So it's private. So any disputes regarding an environmental issue, for instance, if somebody's, somebody next door, your next door neighbor has something that spills over onto your property that damages the environment, then you would likely want to sue them to, get reparations for the damages caused. But having said that, because the environment is such a important area of the law these days, the more likely recourse would be the public law, in that some level of government would likely make your neighbor clean it up as a function of regulations put into place under things like the Environmental Protection Act. right? So the public law is what we're talking about for the most part. Almost all regulatory regimes, again, all those regulations that are enacted as a function of legislation, have what are called command and control regimes in them, in that command is basically, here's what the law is and here's what the regulations are in support of the law that you have to follow. That's command, right? You have to, and this deals with individual citizens or corporations or, or large resource extraction operations, even power dams, those kind of things, from individuals all the way up to very, very large projects. They are commanded to follow whatever environmental laws are put in place to make sure that, in fact, the environment is protected, right? And control are things that, again, go hand in hand with what people are being commanded to do, but the control are put in place to ensure that there is compliance with those standards that are commanded. So we'll talk about those some more. Again, this is just back to what we talked about the private law, basically. So derived from common law or civil law. The example that's given in your textbook is a very, very famous English case called Rylance and Fletcher, which gave rise to essentially the most fundamental rule in private law, is that if you have something on your property of an unusual and potentially dangerous nature, then you are responsible to ensure that it doesn't cause damage to your neighbors. So and if it does cause damage, right, then you're going to be responsible for it unless you've exercised, all due diligence to ensure that damage wouldn't take place. So that's the rule of what's called strict liability, and we'll talk about this later tonight. So strict liability is the fundamental rule in private law. It simply says that if you have the potential of causing harm to your neighbor, you have to put provisions in place so that doesn't take place. So that's the elements of the elementary nature of private law. Okay, so back to public law. So again, governments are the ones that put in place the command and control mechanisms for environmental protection to regulate what's basically seen to be societal behavior, as in the public law, puts in place these statutes and regulations so that society behaves in a way so as not to damage the environment. So it's environmental protection, right? So statutes will set up prohibitions against pollution, and then it will establish and empower government officials to put in place regulations to ensure those prohibitions are lived up to, all right? Environmental laws give powers to enforcement officers. We'll talk about that some more, but obviously that's part of the control of environmental law. And Crown attorneys can prosecute individuals and companies that fail to comply. Again, that's a control mechanism, and we'll talk about that later as well, all right? We have three basic, what are called regulatory regimes that deal with the frameworks for how we look at the environment. The first one is called media-based, media as in not social media and not television, newspapers, media being a type. We'll talk about that. Approval-based and sector-based. Sector-based is going to be the subject of our next class following the midterm exam. So our class a week from tonight will be regulatory sector based on chapter 6. Okay, so the first one, media-based. So media-based simply refers to regimes that are based upon air, water, and land. So they're seen as environmental media, air, water, and land, all right? However, having said that, and even though legislation is directed towards those individual environmental medias, they're pretty much artificial to a great degree, because what happens in one media will tend to impact other ones. For instance, environmental damage on a land, whether it's a landfill site or what have you that isn't properly controlled, will likely leach through the soil into a water-based resource near it. All right, so the media approach tends to be pretty interactive. Approval-based regimes basically is that governments put in place regulations, statutes and regulations that basically say, that you can carry on this particular activity and we will give you approval for it. But in order for you to get approval, you have to meet a number of conditions. in order to get that approval. And then if in fact you meet all those conditions and do get our approval, and it could be, it could be evidenced by way of permits or licenses or what have you, once you have those in place, you still have to maintain the standard of care that we put in place to make sure that even though the approval is granted, your ongoing use of your air, water, or land is still protected. And lastly, we have sector-based regimes which deal with very individualized sectors. And again, we'll deal a lot more on that next day, but sectors dealing with energy, so things like nuclear plants, that's a sector, or forestation is a sector, or water or lakes and oceans is a sector. So those are, and so there's some very specific kinds of legislation and regulations dealing with sectors that just focus on the particular environmental concerns in those particular sectors. All right. And then again, there's an overlapping nature of all these regimes. So both approval regimes, basically interact with the media regimes, which again also are, basically encapsulated in individual sectors. So not only, is there a overlapping of environmental concerns between media, but also between the various kinds of regimes. So that's all you need to know about that, basically. What we've had over time is what's called a more integrated environmental assessment and planning approaches. Environmental assessment is another whole lecture we're going to do probably a week from tomorrow, a week from next Thursday. And it's something that has developed over time. So environmental assessments and planning is something to put in place, which is really a more integrated environmental regime that is very specific with respect to how those people who want to proceed with developments on land or water, what assessments have to take place before any approvals will be given for that. So they become referred to as more holistic, integrative, and preventive, right? So again, environmental assessments take place, for instance, always before a pipeline goes forward. So you'll come across that when you do your group presentations with respect to environmental assessments for the Coastal GasLink pipeline going from Alberta to British Columbia. That's an important piece of that, that puzzle. All right, so this is called a deeper dive into the command toolbox. So again, back to statutes. So clearly, the first avenue for command, for the environment are statutes. So these are things that are passed by the federal government and the provinces. So statutes set out the framework for how the command structure is going to be placed to protect the environment. Statutes also say, basically who is responsible for putting those standards into place, and then the compliance of those standards is created through regulations. And regulations, again, are secondary to the statute. That's why they're called secondary legislation. They will in very specific terms, delegate very specific power of enforcement and compliance to very specific, not the individual person's names, but their roles, their titles within the Department of the Environment or what have you. So that's what regulations does, and obviously it does things like pollution control, standards for construction, waste management activities, effluents, going into, for the most part, onto land and into water. All right. We also have what are called policies and guidelines, right? So these aren't necessarily legally enforceable, but can influence environmental behavior. So you have a number of them, and again, these are governmental documents for the most part that give guidelines to how things should be approached over and above what legislation and regulations may say. So if we go back to the video on the Walkerton water tragedy, the report, the 121 recommendations by Mr. Justice O'Connor as a function of that tragedy, those are guidelines. Right, so he recommended these things. They don't become law, right? Just because a judge in his position on the Superior Court basically says, these are my recommendations as to what happened at Walkerton and how it should not ever happen again. Just because he says so doesn't make it law. So in order for them to become law, then the appropriate legislature, so in the Walkerton case, the government of Ontario, would have to say, yes, we will implement those recommendations and put them into law. And as a matter of fact, if you saw the video, it said that the provincial government, virtually within minutes of those recommendations being published, said, yes, we'll implement every one of them, which was a totally impossible thing to actually take place that quickly. So, and in fact, even today, 20 years later, some of those recommendations still aren't in place, but they certainly were influential in creating a new bit of command and control, right? Approaches to standard setting, we're going back to the precautionary principle. We've talked about this last day and a couple of weeks ago. So the precautionary principle is firstly one of the very first principles of environmental protection that basically says that even without necessarily the scientific evidence that we have in front of us today, what we have to do is we still have to put into place statutory and regulatory regimes that address the potential long-term adverse impact of things that could harm the environment, right? So that precautionary principle is still very much of the command and control structure in Canada. All right, the control toolbox, the things that make people comply with commands. So you have things that incentivize them to do so, things that deal with money, for instance. So you have government programs that assist potential polluters in meeting pollution control standards. Some people question why tax dollars should be spent subsidizing businesses, but the reason for, well, I'll ask you, who would venture a guess as to why tax dollars are a legitimate use of money to ensure that businesses comply? Any suggestions? No? Well, the reason is pretty simple. If we're going to protect the environment as best we can, then we have to use all the tools that are at our disposal. And which means if you're a government, there is absolutely nothing wrong with setting aside funds to incentivize businesses to do the right thing, because they're not going to do the right thing out of goodwill for the most part. Businesses are for the most part, in the business to make money. And so, spending money that comes from the government is a much better way to do that. Arette, you raised your hand?
Yeah. Can you restate your question?
I was just going to say, why would it be a legitimate use of tax money to incentivize businesses to put in place pollution control?
Oh, but that's a tricky question, because we're using everyday ordinary person's tax money to incentivize companies that are already making billions, which can be argued they're not inputting as much as they should into the coffers. Then why don't we target them specifically to tax them according to their earnings or profits, so their contribution can be sizable according to what they earn, where perhaps less burden is on the average persons?
All right. Well, so your answer was the converse of what I was saying, and that's perfectly fine. But of course, we don't, for instance, say to all companies, big or small, that you must set aside X% of your retained earnings to go towards the environment. We don't do that. We don't tax them. We don't have an environmental tax other than a carbon tax, which is very much almost like what you're talking about, Arette. Yeah. But we do. It's a much better approach to spend money, and this is if you're a government, on making sure that harm doesn't take place, than trying to spend money or obtain money by way of, for instance, damages from those who cause it. Right? You want to prevent harm rather than simply put money towards something that is repairing harm. So it's philosophical, and some, as you said, maybe very, very large profit-making companies shouldn't be incentivized, and others like me don't see a great deal of problem with that from a philosophical point of view. Anybody else? Okay. Environmental approvals. All right. So again, this is part of the control toolbox. So environmental approvals, which is again the setting of standards. These are, obviously really an important tool to put in place to ensure the environment is protected. So what this essentially means is that before somebody can do something on land, so this is a development of some nature, they cannot get an approval to do so unless they meet the conditions that the environment puts in place. and all kinds of statutes and regulations are in place for whatever the particular use is going to be. So that's a very effective control mechanism, because if you don't meet those conditions, you won't get a license or a permit to carry on that business going forward. So obviously it's very effective. All right, and so dealing with that, permits, licensing, and approvals, right? So again, in order to get one of these things to proceed with development, it depends obviously on the nature and the scope, the kind of activity it is, obtaining these licenses and permits, will become a precondition to the operations going forward. So in Ontario, pursuant to the Environmental Protection Act, I've taken this from the Act itself, it says this: no person shall, except under and in accordance with certificates of approval issued by the director, that's the director of the department, the government department, shall construct, alter, extend, or replace any plant, structure, equipment, apparatus, mechanism, or thing that may discharge or from which may be discharged a contaminant into any part of the natural environment other than water, or alter or process the rate of production with result that a contaminant may be discharged into any part of the natural environment other than water, or the rate or manner of discharge of a contaminant into any part of the natural environment. The reason it says other than water is that there's a whole separate legislative regime for that, okay? So this system is obviously intended to ensure that nothing is done. This is by resource companies, anybody who, or any business who wants to basically establish an operation, that anything they do doesn't discharge any contaminants into the air, water, or the land. All right, and so the function of that, meeting these conditions will hopefully ensure that pollution from any one of those activities is going to be minimized. Right, and as a function of that, going forward, there are appeal mechanisms and public participation in the environmental approval process. And what these do is they give those people who are applying for these approvals, permits, and what have you, it gives them the opportunity to appeal the decision that's being made. Obviously, it's because their application for a license or permit has been denied, so they can appeal it to a senior environmental official or the Ministry of the Environment, or a body who's been given authority to handle these appeals relating to the issuance of those approval licenses. What they do is, basically, they conduct the appeal. Having said that, there is relatively little public participation in these processes. So, a company who is applying for a license or permit, there's likely going to be some public participation in the issuance of it, but very little in the appeal process. So it's much more of a legal environment. Pollution setting or standard setting for pollution itself, right? So, it's clearly something that's incredibly important. And actually on the standards, which is the control part of the toolbox, deals with how much pollution will be allowed to enter the environment each year, right? And that's kind of a funny question. How much pollution will be allowed to enter the environment, right? So if you ask anybody on the street or any of you how much should be allowed, the normal answer or the natural answer would be none, right? Who would allow it? But that's not a realistic kind of thing, right? Every kind of human activity does create some kind of spill off, or something that will be generated as a function of that. And so a zero contamination premise is not actually realistic. The Canadian approach has been to control discharges on the basis of emission standards for very specific substances. So this is certainly scientifically driven, right? So for the protection of air qualities, the federal government has produced a set of what are called non-binding ambient air quality objectives for several key pollutants. And for each of those pollutants, there are 3 concentration levels. So these are kind of interesting to pay attention to. So one level will be what's called the tolerable level, which is a threshold in which a response is required in the interests of public health. So anything beyond what is considered to be tolerable will get a response. You have what's then called the acceptable level, which indicates that there has been adequate protection put in place to protect the environment and health. It's acceptable, but doesn't mean zero, right? And then the optimum is called the desirable level, which basically can be put in place to protect the environment or the air quality for the long term. All right, so those are 3 different levels. None of them mean zero emissions. All right. In 1986, the federal government introduced this, the Municipal Industrial Strategy for Abatement, to control the discharge of contaminants into surface waters. Okay, so we just dealt with the air. Now we're dealing with surface waters, lakes, streams, rivers, what have you. The objective of this was, the virtual elimination of persistent toxic contaminants. So not all contaminants, but those that are considered toxic from entering all of Ontario's waterways, right? Initiatives like this were also introduced into Alberta, Manitoba, Quebec, and British Columbia. It's really interesting to note that this was put in place in 1986. The Harper government in 2011, 2012 enacted amendments to the Navigable Waters Act that removed this protection to 99% of all waterways in Canada. All right, and it has been replaced by Trudeau. So Harper did that. Okay, drinking water. So drinking water supplies, again, are drawn from both surface and groundwater sources. So again, as I mentioned this earlier, water supplies from municipalities that tend to be adjacent to large bodies of water will often draw their drinking water from that. They don't have to, but they can. They can also draw it just the way other municipalities draw it inland by way of deep wells that tap into the aquifer, which is going to be, hundreds of feet below the surface. Obviously, there's a vital connection between the water quality that you drink and human health. We saw that in Walkerton. So municipal waterworks, these municipalities, for the most part, have the internal jurisdiction to provide water and sewage works for municipalities. So our drinking water and our sewage disposal is dealt with by the City of Sault Ste. Marie, which again is created by the province. And so the province has the overall authority over it, but the actual internal workings of waterworks and sewage works is municipal. All right, and I'm going to show you a brief video on First Nations water crisis, which you'll recognize. Let me see here now. All right, so let me just go back here. I'll get this right yet, guys. I want to make sure you get the sound for this. Stop the share. Wow, finally. All right, guys, let's watch. This is Dean Sayers. He's the chief of Batchewana next door to us. So let's watch this.
Batchewana First Nations. So Chief Sayers, tell me a little bit about how unsafe water has affected the health of your community.
Well, good afternoon, Andrew. Thank you. We really have some issues with the water and the condition of the water. In particular, we have to bring in a lot of bottled water because people can't drink the water. In some of our villages, Batchewana has 3 villages on the eastern shore of Lake Superior in the Sault Ste. Marie area, and a lot of our people can drink their water. We have access to clean drinking water through the City of Sault Ste. Marie, but a couple of our other communities struggle at various times. There's boil water advisories, and when there are boil water advisories or our water has a bad odor or there's some issue about the water, our people don't use it. We honor those kind of cautions. So in those instances, we end up having a lot of bottled water brought in, and sometimes big cisterns of water, and those carry a huge cost to be able to provide people with bathing water, drinking water, cooking water, washing their clothes water. And at first glance, you wouldn't think that wouldn't be so bad, but we don't have an envelope for that. So we take it from programming. We take it from here, we take it from there, children's programming, teen programming, health programming. It's all about health, but we struggle. And it's really not fair to our people who are already struggling to be able to enjoy a good quality of life. We have so many issues already. So it's really unfortunate. It's not fair that in this day and age that we don't have quality drinking water, quality water to use daily as a people.
And why is that? And I can understand the ripple effects that it would have. Why is that there are some villages that some of the time or a lot of the time the water is just not safe to drink or use?
Well, there's a lot of development in our territories. There's a lot of development around the shores of Lake Superior. I think that a lot of that development does have an effect on the water situation, including our wells. So, contrary to what a lot of Canadians believe, we pay the biggest tax. Canada holds a lot of the revenues generated from our territories, and we have relationships that are not being fulfilled about how those are supposed to be shared with us. So those monies that are held by Canada are more than enough to provide us with equitable, quality drinking water, the same as every Canadian. So Canada needs to invest. There is more than enough money to take care of our water needs, human right needs. So that's what we're calling on Canada to do. If we had the same quality of systems that there are in mainstream, we wouldn't see these boil water advisories. We wouldn't see skin conditions and rashes and stomach issues and digestive issues and all kinds of issues that are really unnecessary today in 2016.
Now, this report also talks about how some communities, just out of frustration, that they no longer follow boil water advisories. Does that happen on your territory?
Yeah, I hear that. I hear there are people that are using the water, they boil the water, and sometimes boiling doesn't quite do it. So our health department is aware of the water issues. We have a lot of, availability of programs to be able to educate our people through our health program and our health services. We don't encourage that whatsoever. Yeah.
Do you have, now, the report talks about how the federal government, that they have a history of overpromising and then underperforming when it comes to providing, safe drinking water. So do we know that there is a new government? Do you feel confident that this problem is going to be fixed, or have you seen too many times where just there have been promises and nothing's happened?
We've actually our leadership has met a couple of times with senior Indian Affairs officials, and they've made the commitments to us to be able to address our water issues that are probably in the neighborhood of about $5 million that's going to be needed to provide communal water systems in some of our outlying communities. And we have to go through somewhat of a business feasibility type of an approach first of all, which is kind of concerning me because the clock is ticking. We need good water now. So I'm encouraging Canada to just meet our required needs and provide the envelope to be able to maintain the same quality of water that every Canadian enjoys. And it's pretty easy. It's a pretty easy exercise, I believe. So we can look at another approach, but I'm kind of optimistic. I'm fairly optimistic that we're going to see the proper investments in the next short while, within a year, to have all of our water systems fixed, at least in our particular villages. Now, the federal government has also committed to having all of the boil water advisories lifted within a couple of years, within the 5 years or 4 years. So we're kind of thinking positively about our new relationship with the Canadian government since the new government came into place.
And just on a personal level, you have people in your community. What do they say about all of this? It's
hard. It's hard because they have a certain amount of, they believe it's the leadership in the First Nations communities that are actually the ones that aren't doing what we need to do in order to get the quality water. But we've been running into a brick wall for so many years, not getting anywhere. And no matter how much noise we made, no matter how many times we protest, no matter how many times we did studies, there just didn't seem to be an appetite on the part of the federal government to invest properly so that we could enjoy the same quality of life as the settlers to our lands do. And that includes the provision of a basic human right. Water is such a basic human right. And we've not been able to enjoy that. It's a guaranteed right.
For how long?
As a people, I think we've had instances up to 20 and 30 years where there's boil water advisories. In our particular villages, I think we've probably seen water issues for the last 20 years.
That's a long time.
We just discovered uranium in the last 10 years in our water systems in one of our villages in the Gooley Mission and the Gooley community. And we're not any closer to a resolution, so we end up having to ship a lot of bottled water there. But I'm confident that we're going to get through this, and we are ready and willing, and we want to sit at the table with Canada, and we want to see the proper investments out of our resources, out of our revenues to be able to address this properly.
Chief, we appreciate you taking the time. Thank you very much.
See that bright brain full of excuses for my bogginess. I was just tired, distracted.
All right, guys, let's hope that stays there. Okay, any questions or comments about that piece? I mean, it's right next door to us. Anybody belong to Batchewana in the class? No? My son, I'm sorry?
I do.
Who said that?
Sarah.
Hi, Sarah. Is Chief Sayers correct? I mean, has there been anything done? That's 4 years old, that video. Anything done with the water on Batchewana?
Not that I noticed. I still see a lot of water being shipped to our reserves. I mean, I don't live on reserve property anymore, but when I did, which was last year, nothing. I didn't see any change done within, like, from 4 years ago till now.
Yeah, that's my understanding as well. I mean, you know, there was a lot of promise when the Trudeau government was originally elected in 2015. They were seen to be very enlightened. You know, certainly they were seen to be the total opposite of what it, you know, of the 10 years of the Conservative government of Stephen Harper. But you know, the promise hasn't necessarily been fulfilled. So, and I don't think that what Chief Sayers was hoping was going to take place within the next few years actually did. So thanks for that, Sarah. All right, guys. So now we're going to deal with administrative compliance, which is basically an issue dealing with pretty much an alternative to the standard criminal prosecutions that are possible when there's environmental harm, right? So, you know, basically what happens is that you know, administrative compliance is regulatory compliance, dealing with the approvals and permits that are required. And it's a way to do it without a great deal of penalties that are punitive, right? There's a number of things that take into account administrative compliance. So the first thing you have are what are called reporting obligations, right? So those people who are granted licenses and permits to do a number of things have to usually provide on a very regular basis environmental officials with information on an ongoing basis as to what the operation is that they were given the license for in the first place. So water treatment facilities, and this goes back to one of the questions we had earlier about, is Ontario's water fit to drink? Well, you know, all water treatment facilities in the province have to conduct regular testing and report the results. The only question that gives rise to that particular point is whether those results are transmitted to private bodies and laboratories versus public bodies and laboratories. So that's an issue. Waste disposal sites are required to report the nature and volume of materials collected or delivered to them. This is talking about landfills. So you guys would all know this. I mean, you know, everybody who puts their garbage out every week, some of it is recycled, not nearly as much as you think is recycled, but the vast majority of waste generated by humans goes into landfill, right? So there is a landfill site somewhere outside of Sault Ste. Marie. I don't know where it is. Some of you may do, where in fact you have a dump. It's the town dump, which would constantly have refuse delivered to it, and then constantly have it being plowed under and basically capturing the refuse that way. There are notice requirements in Ontario with respect to when pollution is actually spilled into the environment from a structure, vehicle, or other container that is beyond what is part of the normal operations of a business. So in fact, if that does happen, the owner of the business has to make a report to the appropriate body, right? And when this happens, you know, when you keep track of all of these kind of things, what happens as a part of that is that it creates a record, right? And it's a permanent record. You know, it's now going to be it's going to be online now for the most part, but it's a permanent record full of reports as to how well a certain business has lived up to its environmental obligations. And in the event that there is an environmental infraction, then all of these reports become part of a body that creates the evidence for a prosecution, right? And so what this has given rise to over the course of years, you got to remember, this has only been in place for the last 20 or 30 years in any real kind of effective form. So, any business that has had any of these reporting obligations to any whatever levels of government or department that are required, those reports would form the basis of whether in fact they have been a good corporate citizen or not. And if they haven't been, then these reports may well be used for prosecution. And what that gives rise to, because it's a prosecution, so we're talking criminal here, it gives rise to, Section 8 of the Charter, the right to be safe and secure from illegal search and seizure. And so here's the case that this was brought up, and this is a case called Regina and Fitzpatrick, and it dealt with charges against someone who was fishing, who the allegation was that he overfished his quota. Right, so this isn't somebody who's indigenous who argued that he had the inherent or traditional right to fish and to fish whatever volumes of species he wanted to. That's an indigenous right. This is somebody outside that. This is somebody who's non-indigenous who is charged with overfishing his quota. And what was used in the prosecution, of course, was the daily fishing logs that he was required to keep under the Fisheries Act. All right, and so this is evidence that he actually created himself. So the question came, the defense counsel said that those records could not be used into evidence because it was, you cannot self-incriminate yourself in a criminal case. Basically, you have a charter right not to be self-incriminated. What the court said is that charter right doesn't apply in this environmental context, and the reason for it is this: that the keeping of records, basically for the purposes of keeping track of species and quotas and all those kind of things, are not created for any adversarial process. They're created in a regulatory process, so they're not created for the purposes of criminal prosecutions. So fishermen who agree to participate in a licensed industry and who basically follow the conditions of their licensing, which includes reporting under the regulations, that was basically seen as not to be self-incriminatory evidence. Okay, so that's the difference between criminal prosecutions, which we'll talk about later, and regulatory regimes. Inspections are always conditions of licenses and permits being granted. So those licenses frequently contain a requirement for ongoing inspections of operations. Right? And environmental legislation provides that designated officials will enter and inspect premises on a regular, or regular being scheduled, or on an unannounced basis. Right? Unannounced meaning you just show up and do an inspection. The statutory powers of inspection, again, these are powers that are put into legislation and regulation, authorize inspectors to enter non-residential, so businesses, because you always have the right to, your home is still your castle. Nobody can enter your home with a search warrant, right? So non-residential premises, meaning for the most part businesses that carry on a business that's been granted a permit, are always going to be subject to inspection, right? And when these inspectors enter, they can take photographs, they can make audiovisual recordings, operate equipment or machinery, conduct tests, take samples, or make reasonable oral or written inquiries. So that's a pretty broad scope of investigation, right? And then lastly, we have what are called administrative orders. So these are orders that promote compliance with legislation, and they're used quite often. They're relatively newly put in place. They've only been around for 10 or 15 years, but this is an effort to put a regime in place that is less adversarial than criminal prosecutions. So administrative orders are basically put in place after there's usually been some kind of a failure with a consultation to resolve an environmental situation. All right, so somebody has done something wrong. There's been some effluent that is leaked perhaps off of their property into a water stream, or there's been some kind of air pollution that's taken place. Something has gone wrong, and consultation with the appropriate person in the environmental regime, the government or department, it couldn't be resolved, right? So the orders are made by the minister, so it's going to be the minister who is responsible for that legislation that was passed. So very often the Minister of the Environment, basically. So these orders can be made by the minister who makes decisions with respect to the long-term management of the problem that gave rise to this particular issue, right? And so this is basically a compliance mechanism put in place by virtue of regulation. You can also have control orders put in place. So these permit, again, appointed officials to put in place measures to control illegal discharge contaminants into the environment, right? And these control orders will include monitoring obligations, equipment installations, replacements, and what have you. And then you also, and these are administrative, can have stop work orders, essentially, which are written, and they basically also include the reasons why somebody is going to be made to stop doing something that, in fact, they're doing and seen to be harmful to the environment, right? In order for these to be put in place, which again, you're interfering with somebody's business, so these are serious. The director who puts it in place has to believe that the discharge of the contaminant is occurring in such a way that there is an immediate danger to human life, health, or property, right? We also have what are called preventative orders, basically. So these, again, and they're based on the preventative principle we've talked about a couple of times. So they're in anticipation of pollution, where basically the orders are used to prevent or minimize environmental damage going forward. Basically, because they are preventative, which means that nobody has done anything wrong when they're put in place. They're looked at very strictly by the courts. They're construed very strictly because they're preventative and not as a result of damage. With respect to the Ontario Environmental Protection Act, it authorizes state intervention. That means clearly environmental officials, the director, to intervene in the activity of a person on his land before any offense has been committed. So this is a precautionary order. And without providing any, and so if the business has not provided any offsetting protection or benefit by way of compliance, right, then the director will intrude, and in view of their own risk management, whatever they put in place, will leave the person with the full responsibility for the risk going forward. Okay, so they won't stop the business, but they will put provisions in place that basically say, if you don't follow these risk management provisions, you will be totally responsible for whatever happens in the future. The comparable federal legislation, the Canadian Environmental Protection Act, provides for the same kind of orders as those under the Ontario Act. Okay, they're seen to be reasonable in the circumstances in that they protect the environment and public safety such that, and this comes from the legislation, measures may be taken to refrain from doing anything in contravention of the Act or regulations. Measures may stop or shut down any activity, work, undertaking, or thing for a specified period. So it's not unlimited. It's a very specific period of time. They can order the operation to be stopped. Any activity of the part of the work or the undertaking is stopped until the officer is satisfied that compliance will be achieved going forward. All right. And then lastly, we have what's called administrative monetary penalties. And these are sanctions that result from any one of those administrative orders we just talked about, right? That tend to be, a less costly mechanism than criminal prosecution, and certainly more expeditious. They provide a more convenient aspect for the offenders to accept a penalty, an administrative penalty, rather than the prospect of a criminal record, which clearly is obviously important. Administrative monetary penalties typically put a regime in place where the contravention of the environment allows for the director to assess a penalty rather than a criminal punishment, right? And it's important to remember in this regard that in order to achieve the goal or the effective nature of administrative monetary penalties, the penalties have to be high enough, right? So that those businesses that are potentially going to be subject to these penalties, as in they are going to in fact contaminate the environment, the penalties have to be high enough so that the businesses just don't look at them as a cost of doing business, which is pretty much what Arette was saying earlier with respect to, should these businesses that make a lot of money have to pay for everything they do, right? So that's what these penalties are. They are very steep, so that in fact it's just not. Last thing you want to do is have a business that will contaminate and then write a check and say we've covered that off. Let's just keep doing business. as the way to do business. These penalties don't, however, provide an offender with his or her day in court. As in their administrative, the director or the minister imposes them, and there's no hearing into having these imposed. They essentially are put in place, and there's no two ways about it. You have to pay them. All right, so that's the administrative monetary penalties. So the next thing we're going to talk about, the last thing we're going to talk about, are offenses, prosecution, and penalties, which clearly is the most serious way to deal with environmental harm. All right. It shouldn't surprise any of you that there are prominent environmental offenses associated with environmental damage. This is something that's been around for quite a while. The Ontario Water Resources Act makes it an offense to discharge or cause or permit the discharge of any kind of material in or into any waters where the discharge may impair water quality. And every person that discharges or causes or permits the discharge of any material of any kind to come into any waters or any shore or bank thereof, or into any place that may impair the quality of water or any waters, is guilty of an offense. All right, this is a criminal offense, right? Offenses in the environmental context generally are described, however, as regulatory, in that a lot of these offenses, while they're criminal or quasi-criminal in nature, are breaches of regulatory provisions. Okay, they can be provisions in statutes. Again, Regina and Wholesale Travel Group, we referred to this earlier. The court said this, the Supreme Court: since regulatory offenses are directed primarily not to conduct itself, but to the consequences of conduct, conviction of a regulatory offense may be thought to import a significantly lesser degree of culpability than conviction of a true crime. All right, so what the court is basically saying is, if it's a quasi-criminal or criminal offense, but under a regulation, that is not likely going to carry the same stigma as that, for instance, under an act or the criminal code, right? The concept of fault in regulatory offenses is based upon reasonable care, and as a function of that, it doesn't imply moral blameworthiness in the same manner as criminal fault, okay? Conviction for a regulatory offense basically suggests nothing more than the defendant has failed to meet its prescribed standard of care, right? Rather than the criminal, basically, requirement of mens rea. All right, anybody want to give me a quick definition of mens rea? I know some of you know this. Anyone, what's mens rea?
It's like basically the guilty mind. So you basically have like the mentality of committing the act. So in this case, they will say, oh, I did not intend to have this much discharge in the environment. They cannot say that. So basically it would only be like the actus rea. The main fact that you actually did it is enough for you to be convicted of that regulation.
Well, and that goes to absolute liability. We'll talk about that, but Lexine's absolutely correct. Mens rea is the criminal mind. So if you're convicted of a regulatory crime, it's seen to be not something that rises to the moral blameworthiness of having mens rea. Right? Each classification of offense has significance for how the prosecution proceeds. Most environmental offenses fall within the strict liability category. So again, I mentioned that earlier. That's the Rylands and Fletcher common law test in England, right? So essentially what happens there is that if you're dealing with a strict liability offense, then what happens is the commission of the offense, which, as Lexine was saying, is the actus reus, will be established on a prima facie. That means at first blush, basically, on the first basis that something is done that has harmed the environment, that the prosecution just has to show that it has been done. It doesn't have to show the necessity of the mental state of the accused, so it doesn't have to show the mens rea, so the prosecution does not have to show that. But it is open to the accused to avoid liability by proving that he or she took all reasonable care, right? So strict liability is quite simply this: somebody commits an environmental offense or a harm. The fact that it's been committed is enough for the offense to be laid, the regulatory offense to be laid, and the only defense to it is that you did everything reasonable within your power to ensure that that harm shouldn't have taken place. So in Rylands and Fletcher, which is the case of the water, the dam breaking and spilling over to the neighbor's property, if Fletcher, that's the person who owned the dam, had done everything that he possibly could have to ensure that that dam shouldn't have broken, right? But it still did. So perhaps maybe it was hit by lightning or something that you really couldn't protect against. Then if he'd done everything that was reasonably up to a reasonable standard, then he would be not guilty of that regulatory offense. The second category of offenses requires prosecution to prove mens rea. So again, these are truly the criminal nature of regulatory offenses, and mens rea includes recklessness, willful recklessness and intent. So again, these are true crime offenses. And the last category are called absolute liability offenses, which requires only the proof of the actus reus. Only means that it means that, again, in Rylands and Fletcher, if the particular offense was one of absolute liability, it doesn't matter how much care Fletcher would have put into place to protect that dam, right? The fact that it spilled at all and went onto the neighbor's property, if the particular piece of legislation that was protecting the environment for that neighbor, it may have been a sector kind of thing, or again, media, the land or water or what have you. If it could, it doesn't matter how the legislation is drafted, but if it's drafted so that liability will flow in the event that it doesn't matter how much care the person who caused the harm took, then that's an absolute liability offense, and therefore the penalty, the conviction will be registered, and whatever the penalties flow from that conviction will take place. Okay? In the absence of express statutory provision with respect to regulatory offenses, the rule of law is that offenses will be considered to be strict liability. All right, so unless the offense requires A, mens rea to prove liability, or B, is not absolute liability, so there is no question that it only takes just the actus reus. So if it's not mens rea and it's not absolute liability, then it's going to be seen as strict liability, which again gives the person who's caused the harm the defense of proving that they took all reasonable standards, so that harm in fact should not have taken place. If the offense is prosecuted as one of absolute liability, and the particular statute that puts it in place has a provision that sets out that one of the penalties is potentially deprivation of liberty, deprivation of liberty, then the charter comes into effect. What's deprivation of liberty? Which is a Section 7 protection of the charter, the right to life, liberty, and security of the person. Anybody, what's an example of a deprivation of liberty? Tyler?
A deprivation of liberty would I guess freedom of speech would be protected under this.
No, that's a separate part of the charter. Deprivation of liberty is going to jail. Depriving you of liberty means that your freedom to move is gone, so you're going to jail. So that's a contravention of, again, Section 7, the right to life, liberty, and security of the person. So what the case law, the common law has determined is that if an absolute liability offense is in place where in fact it doesn't require mens rea, it just requires the actus reus to take place, that's a contravention of the charter's right to Section 7, right? So you cannot have the option, the prosecution cannot rely upon the option of somebody going to jail if the offense is absolute liability. You will not go to jail unless mens rea is a consideration. The charter requires that. Okay. Under the criminal code, there are potential sanctions, of course, under the criminal code, although there's nothing in the environment, there's no reference to the environment in the criminal code itself, right? It doesn't actually say that. So it's a function of other provisions that relates to potential environmental damage that obviously causes serious harm. So again, the criminal code makes no express reference to the environment whatsoever. However, you do have provisions that deal with an environmental context, such as criminal negligence, right? So the two brothers in Walkerton who caused people to die, they were charged with criminal negligence causing death. right? There's nothing to do with the environment, within the criminal code itself, but that is the effect of what they did. They were so criminally negligent that they caused death, and it's a function of that. And it's a mens rea. It involves deprivation of liberty. They went to jail, right? And so it involves the mens rea, or somebody who shows what's called a wanton or reckless disregard for the lives or safety of other persons. So that's how the Capel brothers and Walkerton were caught. They didn't have the criminal mind to kill people, right? They didn't, by not chlorinating the water and falsifying the records, their intent wasn't to kill anybody, but they were so wantonly reckless for the safety of people that in fact that rose to the level of criminal negligence, right? Hopefully everybody understands that. Any questions? All right. Criminal code also has nuisance provisions that it can be an offense to commit a nuisance. Nuisance is where somebody has something that emanates over somebody else's person or property. Like smoke is a nuisance if it goes over somebody's property, or loud noise is a nuisance to your neighbor. That's a nuisance. Those things can rise to the level of criminality if it endangers the lives, safety, or health of your neighbors or the public, basically. You have particular provisions in the Canadian Environmental Protection Act that creates a crime against the environment wherein, and this is, I'll read it to you, every person is guilty of an offense and liable on conviction on indictment to a fine or to imprisonment for a term of not more than 5 years, or to both, who in committing the offense, A, intentionally or recklessly causes a disaster that results in a loss of the use of the environment, or B, shows wanton or reckless disregard for the lives or safety of other persons and thereby causes a risk of death or harm to another person. All right. This is a YouTube that's embedded into the PowerPoint. I'm going to run it. And if you guys can't hear it, let me know. I've turned the sound on for this. But if you can't hear it, somebody just quickly raise your hand and tell me you can't hear it.
In recent years, fast technological advances have made it possible for regulatory bodies and non-governmental organizations to employ a great number of technologies in the monitoring and enforcement of environmental law. Here are 3 examples of how different types of technologies are helping people every day in the fight against environmental crime. Our first stop is in Ireland, where the Environmental Protection Agency has developed an innovative way to increase citizen participation in this process.
NIS was set up in 2004 in response to an ECJ case taken against Ireland, and that highlighted multiple and systematic failure in implementing the Waste Framework Directive. So as a country, we needed to be better organised to combat illegal waste activities, and we needed to be able to work across the country and also across many organisations in order to make a difference. So one of the things we've developed is a phone app, and we call it See It, Say It. So you can use it if you're out in the country to actually report an environmental incident. And the way you do that is you take a picture of the incident with your mobile phone, and the phone will automatically record your location. From that, it can send it directly to the computer system of the organisation that needs to follow up on it. After that, the waste enforcement officer, if it's a waste incident, will investigate. They will come to the site. They will look through the dump to see if they can find any evidence of who was actually involved in it. And if they do, they will take that person to court. They will also liaise with their clean-up crew and organise them to come and bring a truck and clean away the waste, leaving the site back the way it was. On an annual basis, about 2,000 people are downloading the app and using it to report environmental issues. And that covers things like air, noise, nuisance, water quality and waste. And the waste can be anything from a piece of litter to an abandoned car to a larger dump. And the majority of things are in the litter area. It's so easy to be able to engage using the app, and it really has come on from using a phone or using a letter, which was the old way of doing it. So it empowers people to engage.
Reliable evidence interplay. In the community, we rely on people witnessing fly tipping or destruction. However, there was a big issue there, is that it was usually your word against somebody else's word, and also trespassing, that you wouldn't be able to get onto private land in order to actually witness close hand what was going on. Now, with the advent of drones, we've been able to get reliable evidence that you can take into court and take to decision makers. Here's a video, here are some photographs of the environmental destruction. A great example of where the use of a drone has led to a successful prosecution is right here in Blackness Park. A developer bought up a site, and with the idea of degrading it so that it could get planning permission. If you destroy the ecology, then it's easier to build, right? We couldn't go in the site, so we used a drone to fly in and take video and photographs of illegal dumping of waste, leaking radiators, leaking fridges, paint that was leaching into the environment, poisoning the species there. We took this video, showed it to decision makers, and within 24 hours a notice was issued for the removal of this illegal waste, and the site was cleared. Up to now, communities have felt helpless. So through the use of these technologies, communities can very easily gather evidence, and that makes them feel as if they have the capacity to do something about degradation of their environment. It's a new source of information, and information is power.
GPS technologies and satellite images are one of the most ubiquitous technological advancements of the last decade, and something that we can all access with just a tap of the finger. These incredible databases of information allow organizations such as the Committee Against Bird Slaughter to monitor large areas across Europe for bird trapping, a practice that has been illegal in all European member states since 1979, but that unfortunately still leads to the death of 25 million birds a year.
CABS is the Committee Against Bird Slaughter, and we work against bird trapping in the Mediterranean. So when we start a new campaign in an area which are not familiar with, we use normally satellite images in order to get the upper hand on trappers who know this area much better than us. At the beginning we were just using our memory, there was no database, so we would just work spontaneously, relying on our skills of moving in the terrain. So you see only what you can see, but if there is a house or a barrier, you cannot get beyond it. But as soon as you get satellite images, you can cover the whole area and have 100% control over the territory. Satellite images have changed the way we work. They're really important both for security reasons, since you can understand where the trappers come to a dangerous place and how you can hide or find a fast escape route in case they come, and both for locating, reporting and mapping these trapping sites. For instance, thanks to the use of Google Earth in southeastern Spain, you can see these huge installations from the sky, and it's very easy to detect, locate and report all these trapping sites. This is one of them. You see the pinnacles, the prune trees, and moving around you find more of them. This is another one. You can see the prune trees, another trapping site. So you can have the control over the whole situation in a short time. I can also show you an example from Cyprus, where we located a trapping site and we had the first successful ambush and prosecution with the police. And so this is the trapping site, and we could show the policemen where we believe that the trapper would arrive from using this road, where they could hide the cars in order not to be spotted before their arrest. And actually it worked.
New technologies are proving increasingly useful in reducing monitoring costs, increasing safety for inspectors, and allowing communities to gather evidence. However, such techniques cannot yet replace traditional enforcement and surveillance by statutory bodies. They should instead be seen as tools for the benefit of an already existing network of enforcement agencies, and also for citizens interested in helping to protect their environment.
All right, guys, I'm glad that worked. Sorry for the bit of a break. I want to just make sure you got to the technology part. So good stuff. Okay, so enforcement policy and prosecutorial discretion. These are two general approaches to enforcement. The first one is conciliatory. That's the enforcement policy, and the second one is enforcement based. That's the prosecution. All right. So conciliatory approaches consists of what are considered to be non-coercive measures and negotiations intended to encourage or promote environmental performance consistent with established environmental standards. And that's the approach most often taken in Canada. So when it comes to consultation, and resolution is what is fundamentally the way going forward, rather than prosecution. All right. Prosecution tends to be a bit of a zero-sum game. Somebody's being prosecuted, they don't tend to be cooperative in doing what they have to do to protect the environment. Whereas if it's a negotiated consultation, then it does. The enforcement strategy obviously relies upon prosecution, formal penalties, and sanctions, right? By way of a background to the Canadian Environmental Protection Act, the Minister of the Environment stated that more than fines are needed by way of punishment because money is only the item on a balance sheet. And again, that goes back to the severity of administrative monetary penalties, right? So again, fines, which is a very common criminal penalty even when a conviction is registered, is not necessarily that dissuasive, right? So the way the act is structured now is that the responsibility lies on the shoulders of the executive officers and presidents of the corporations that commit the environmental crimes. And this is really important. All right, so before the Canadian Environmental Protection Act was amended, if a corporation subject to its jurisdiction was found to have committed an environmental crime and a conviction was registered, then the corporation itself was the entity that paid the fine. All right, what the act did in basically imposing the penalties upon the people who ran those corporations, you guys can get the picture, right? That obviously creates a much more direct, deterrent to the individuals who run companies, where in fact they are not going to personally have records and or responsible to pay fines. Okay. The act also sets out that individuals can be subject to jail from 1 to 5 years. So again, that's a very serious penalty now for those people who run the companies that potentially cause environmental harm. It's intended that the government will enforce that law with vigor, so it's up to obviously the department and the Ministry of the Environment to do so, basically. Statistics show that prosecution has a significant impact upon environmental behavior of corporations, both with respect to past behavior and the prediction of future behavior. That's obviously a good thing. Corporations that have experienced prosecution have had higher levels of environmentally related spending than firms that did not. Okay, so basically it's acted as a specific deterrent to these corporations that if they were prosecuted in the past, they tended to spend more money in the future so as not to be prosecuted again. Likewise, the executives are more likely to take action with their companies to avoid offenses if they're going to be personally responsible for those offenses, right? That just makes a lot of sense, right? Investigations for the purposes of environmental harms are characterized by visits to determine whether there is compliance with a given statute. That just makes sense. The basic intent is not necessarily to uncover the breach of the statute, but rather to protect the public. So it's not an enforcement mechanism, but a consultation mechanism, right? However, if the inspector enters an establishment and finds that there has been a breach of the statute, then the inspection becomes a search, as in a search and seizure, bringing into play the provisions of the criminal justice process and the charter, right? To go further, however, other than instituting the search, then it's highly likely that the inspector is going to have to get a search warrant. So he or she is going to have to go back to a justice of the peace and swear out an information that there are reasonable and probable grounds that an offense has taken place under the legislation that would warrant, in fact, a search warrant to go back and then do a more serious search. Again, Section 8 of the Charter specifies that everyone has the right to be secure against an unreasonable search and seizure, hence the requirement for a search warrant, right? And then the last thing we're going to talk about is private prosecutions. So private prosecutions are prosecutions where if you see somebody who is, you think, committing an egregious harm to the environment, and you can't convince some environmental official or the Crown Prosecution Service to lay a charge against them, then you have the ability under the criminal code to bring what's called a private prosecution. So in fact, you become the prosecutor. So what you do is, again, you go to the justice of the peace, you swear out information, setting out what you believe to be the offense that's taken place. And then if the justice of the peace agrees with you, then a prosecution will start, and you take on the role of the Crown in that particular case. However, it's always overseen to some degree by the Crown Law Office in whatever county or district in which you bring the charge. So if you did this in Sault Ste. Marie, then Kelly Weeks, who's the Crown Counsel for Algoma District, whose office is in the Sault, her office will have an oversight of what you would be doing as a prosecutor, and her office has the authority at all times to bring it to an end, right? Which is called staying. She has the Crown Office has the opportunity to stay a private prosecution, right? Which basically means they don't think it has any possibility of success. With respect to particular penalties in the conviction of environmental offenses, they're the same kind of penalties as imposed under the criminal code, right? So punishment, these are principles of sentencing. Punishment and deterrence are objectives of sentencing, but they're always tempered with protecting the environment for the public interest, right? So as such, again, sentencing principles, the evocation of remorse and the prospect for rehabilitation are more important than strictly punishing somebody. You know, those elements of sentencing are more conducive to reparation of the environment rather than somebody simply being imprisoned or fined or what have you. Under the Canadian Environmental Protection Act, there are a variety of penalties. They include this: A, prohibiting the offender from doing any act or engaging in any activity that may result in the continuation or repetition of the offense. B, directing the offender to take any action that the court considers appropriate to remedy or avoid any harm to the environment that results from the act or omission that constitutes the offense. C, and lastly, directing the offender to prepare and implement a pollution prevention plan or environmental emergency plan. So as you can all see, that while environmental sanctions can be very much like criminal code sentencing and sanctions, there's also a lot of leeway directed towards the ongoing protection of the environment in the future. All right, the last thing we have is a very short video, and then we'll move on to the breakout sections.
Hi, I'm Alex, and I'm going to tell you a story that actually happened to me. I went to a government office.
Hi, I'm Mary, and I work for the AEP. If you have any questions or feedback related to us, you can come to this office to ask me directly. Your feedback is important to us.
Good morning, I'm Alex. How are you doing?
I'm good. Today's weather looks good, eh?
Yes. No snow yet. Actually, I saw a moose on my way here.
Eh. Lucky you.
I have questions. Who can I ask?
You can ask me. I'm Mary. What can I help you with this morning?
When I was driving through Black Diamond, I came across a small gas station. By the way, why is it called Black Diamond?
In the past, coal was called Black Diamond, and there were some coal deposits near the original town site.
I see. What was my question? Right, I came across a small gas station. Good morning, sir. This pump's nozzle looks much bigger than the others I saw in other gas stations. Oh, this was fire engine hose's nozzle. So, you refitted your pump with a much larger nozzle? Sure, why not? Looks, this one has larger opening, so I can fill gas tanks much quicker. Young man, you have no idea how sluggish the economy is. Actually, I just graduated from the EVT program at SAIT. I thought that this might be illegal, am I right?
Yes. Actually, in this case, a ticket can likely be issued, because the flow rate is likely too high.
If I remember correctly, that is under the Canadian Environmental Protection Act.
Yes, CEPA was created for pollution prevention and the protection of the environment and human health. The maximum penalty that can be issued, is 1 million or 3 years in prison, or both. Tickets can be given for offenses under CEPA, where there is minimal or no threat to the environment or human life or health. Where an offense is designated as ticketable, enforcement officers will always issue a ticket.
How do you know that the substance is actually considered toxic under CEPA?
Well, if you take a look at Schedule 1 under CEPA, gasoline contains toxic substances such as benzene. Actually, there are also some other regulations related with gas station, if you were interested.
Oh, if you don't mind, could you please tell me what a regulation is, since I sometimes slept in my environmental law course?
Ha ha ha. Regulations are a form of law that have binding legal effects and usually state rules that apply generally.
So, where are regulations proposed under CEPA published?
Good question. It is published by the Minister in Part 1 of the Canada Gazette, Canada's official parliamentary journal.
What is considered a regulation under CEPA?
Let me think. Actually, there are a wide range of regulation designated under CEPA covering different types of activities, chemicals, and emissions, such as benzene and gasoline regulations, gasoline and gasoline blend dispensing flow rate regulations.
The one you just mentioned, what is it all about?
It prohibits retailers and wholesale purchaser consumers of benzene containing gasoline and gasoline blends from using, or offering for use, any nozzle to dispense those fuels into on-road vehicles if the flow rate from the nozzle exceeds 38 liters per minute.
Does the motor vehicle safety regulation belong within the CEPA?
Yes, that was passed under the Motor Vehicle Safety Act that controls vehicle emissions remains in effect under CEPA.
I'm sorry to ask you so many questions.
It's okay. Thank you for keeping me busy.
Actually, I have one more question.
Shoot.
What recourse does the government of a foreign country have if the government believes it would be negatively impacted by the new regulation?
I am not really sure, but under certain trade agreements like NAFTA, foreign companies can sue Canadian government if they feel that the increased regulations hurt their businesses.
Thank you so much for your time and answers. I am going to pass Black Diamond again. This time, I will tell him what he did wrong. Hopefully, he will accept it and change back the nozzle to the right size.
There we go. Okay, so that's the lecture. So now we're going to move into the breakout rooms. So again, you guys have this down pat now. There are 5 questions that I posted on Moodle dealing with today's lecture. So they're there. I'm going to break you out into 5 rooms. You know, again, group breakout room number 1, question number 1, 2 and 2, etc. I'm going to do it for 20 minutes. That seems to work well. So let's do that, you know, and then we'll come back to the questions after the breakout, and then we're done for the evening. Any questions before I do any of this? Any questions about the lecture? Are we good? Hopefully. All right, guys. So I'm going to do the breakout rooms right now, and then I'll see you in 20 minutes.